Okay, good. So we're gonna do the 2017 July question four. So Ethan, starting July 17, question four, civil procedure. Five calls of the question with a very short fact pattern. So that tells you when you have five calls of the question, they're not all going to be home runs. Um, you're not going to have a lot of time, so you're not going to go into a lot of detail. You may go into a lot of detail on one, but not the other. So let's take a look. Number one, may the buyer join claims for fraud and breach of contract in the same suit against seller? Well, the thing about that is, I already know, according to Rule 18, which is actually really confusing when you compare it to subject matter jurisdiction, not even reading the fact pattern. The answer is yes. You may always join all the claims you have against the defendant. Doesn't mean the court's going to hear them, which is the difference between what's going on in number one and number three, which is very interesting that the examiners did that. So Rule 18 gives you the ability to join all claims all the time. Don't worry, you don't need to know rule numbers. I just happen to know the rule numbers for these because Rule 18 has always frustrated me. That's why I know the number. Because I remember saying, why is Rule 18 here? It doesn't make any sense because you still have to deal with subject matter. So you may always join all the claims you have against the same defendant, even though the court may or may not have jurisdiction over it, which is a whole separate issue. All right, number two, is the buyer's allegation sufficient to state a claim for fraud involving the painting? And for number two, I already know, like, this is either, I think it's 9A or 9B. Somebody check me on that. All I know is that, and I've seen this on the MBE, whenever you allege fraud and some other things too, but fraud's the main one they test. In fact, it's the only one I've ever seen them test. You have to state it with specificity, means you have to give facts and details enough to show that a fraud was committed. There's some kind of policy or rationale behind it that states that if you're going to make such a, what's the word, I guess, serious claim, that you have to add more facts in the complaint rather than just something very simple. Because most of the time you can just allege that, the person was negligently driving and hit me when I was in the crosswalk, which is fine, which according to the pleading rules. But for fraud, it's a special pleading. So you have to add more. So right off the bat, I already know the answer to these two without even reading the fact pattern. Of course, that's not going to happen all the time. Number three, does the federal court have subject matter jurisdiction over the suit? Well, it's either going to be one of two things. It's either going to be federal question or diversity. And if we have one of those two, then maybe we're going to have supplemental jurisdiction if the other claim doesn't independently satisfy it. So right off the bat, I'm kind of seeing how everything's going together, which is why we always go to the call to question first. And notice that I'm not just reading the call, I'm thinking about the call. Of course, on the exam, I'm not going to spend, if you don't know it off the bat, I get it. Sometimes I might even be wrong when I do this. Although here, I'm not. So number four, may the federal court apply California law. So either, it must be Erie. Turns out I don't think it is, to decide the breach. So much means, so he must be diversity. Because how else are you going to apply California law unless it's a diversity case? Because you'd apply federal law if it was a federal cause of action, because you're suing under the federal law. So that kind of gives us a little tip right there, probably diversity. And guess what? Since they've never tested federal question, I've seen on an essay that I recall, you're going to be discussing diversity. Why? Because there's more to discuss. So may the federal court apply California law to decide the breach of contract claim? So we know it's a state law claim. So we know it's not a federal question, at least for that one, involving the real property. Well, generally they do what's called situs of the property or in rem jurisdiction. And I don't know which one the examiners were looking for here, but the real property is always decided by the jurisdiction in which property is located. That's just how things go. So when you have quasi in rem, what will happen in quasi in rem is, but don't even worry about that. I don't want to get into that. Okay. So here we have either situs, Erie. Number five, on what issues, if any, would the buyer be entitled to a jury trial? And once again, that's a pretty easy one. Well, any kind of legal issues are tried to the jury first. Equitable issues are tried last. And I'm telling you something, that's to the judge. And no matter if it's the plaintiff or the defendant who files, because if the plaintiff files for equitable relief, let's say specific performance or an injunction, and the defendant counterclaims with a let's say breach of contract or some type of action that's a legal action for damages, right? You will still get a jury trial on the legal issues first. And then the court decides the actual issues afterwards. This is one, Dairy Queen and Beacon Theater. If you want to write that down, Dairy Queen, Beacon Theater. Why? You will 100% see that on the MBEs. So in the outline under Dairy Queen and Beacon Theater, one of those two tests, one of those two cases, or a combination of the two, will 100% be tested. I've seen it on every single Civ Pro MBE. And it's a super easy question. You can't miss. I even seen them when they had like a suit for accounting. And I think that's one of the cases where the movie theater, like they asked for an injunction, and the accounting, I believe, was legal, and they get a jury trial on the legal issues. So right there, the call to the question actually lays out everything. So this is actually, to me, this is a really fun essay. And I love doing this one. All right, so let's take it from the top. Buyer who is living in New York and seller who is living in California. So the first thing I'm going to do is on my paper, I got buyer, New York. I got seller, California. Because I got to know who's who and what's what. Entered into a valid contract, agreeing to buy and sell a painting claimed to be an original Rothko, supposedly worth $1 million. Mountain controversy satisfied if that's the case. And we know that there's a breach of contract claim somewhere here, and we have a contract claim that's going on there. So I'm putting that together for number one. For that amount, in a separate valid contract, so there's two separate contracts. Buyer agreed to buy from seller a parcel of California real property worth $5 million for that amount. The buyer and the seller completed the purchase of the painting on June 1st. They were to complete the purchase of the real property on June 30th. All right, so these are two separate contracts. And it's interesting when we get into contracts, it's a law that I really don't care for, is that if you breach one of, say you have two separate contracts like we do in this situation, and we find out the guy committed fraud with one of them, do you have to go through with the other contract with this guy who you no longer trust? The answer is yes, because there's two separate things. So if party A breaches this contract, party B can't say, well, then I'm not going to go through with this contract. Now party B is in breach on that one. So they're actually treated as completely separate, which I don't like, because if you're going to rip me off in one thing, I'm not trusting you with the other. Well, I'm not buying your house if you rip me off on the painting, or vice versa. Because I don't trust you anymore, and I don't want to do business with them. Okay. So Ethan, if you're around, will you take care of that thing? Thanks. On June 15th, buyer resold the painting, but obtained only $200. So he obtained $200 because the painting turned out to be fake. Got it. So we have breach of contract, and damages there would be not $1 million for the painting, because I think they agreed $1 million. Damages actually be $999,000. 800. There you go. And that's the amount of controversy. You can just put $1 million for sake of the bar. Buyer promptly notified seller of his intent to sue seller for damages of $1 million. Okay. Seller then informed buyer that seller would not go through with the purchase of the real property. Believe it or not, seller's in breach right there. That's an anticipatory repudiation. Hey, I'm not going to do it. I'm not going to go through it. So now the buyer can actually sue the seller there. Okay. Buyer filed suit against seller. Okay. In federal court in California. So in order to get into federal court, you need subject matter jurisdiction. And how do you get subject matter? Well, there's no federal questions here. We have two breach of contract claims. And so
Diversity.
we have diversity. We have New York, California. We got $1 million contract.
We have diversity.
And we got a $5 million contract. Whoever is, could you please mute yourself, Rashawn? Ethan, could you please take care of that? Thanks. Let's see. So buyer filed suit in federal court in California. Buyer claimed fraud as to the painting. Okay. Fraud is the painting. Got it. Alleging only that seller committed fraud in supposed value. Well, they make it very clear that under no circumstance can you say those allegations are sufficient to support a claim for fraud, because you have to plead fraud, I think, in specificity, or however they title it under rule. It's either 9A or 9B. That's the rule. Okay. So, and sought specific performance. I'm sorry, so $1 million in damages for the buyer versus seller for the painting. Buyer also claimed breach of contract as to the real property because seller actually did breach by saying, hey, I'm not going to go through it. That's an anticipatory repudiation, and sought specific performance. Okay, so that is the equitable claim. So we have the equitable claim for specific performance. We have the legal claim for the $1 million for the fraud painting. So if these cases are, if both these contract claims are together and end up being together, then we're going to have a jury trial for the painting first, and then the judge will independently order specific performance of the real property if he so agrees with whoever breached. Buyer demanded a trial by jury on all issues. Well, he won't get a jury trial as to the real property for specific performance because the judge determines equitable claims. Jury determines legal claims. And the legal claims always go first, even if they're tiny, even if they're small, because sometimes you'll see like the equitable claims will completely dominate the lawsuit and there'll be just one small little legal claim. Still, that gets tried to the jury first. And that's part of the Seventh Amendment, where their federal courts will apply. If you're in federal court, you're going to get as long as you're timely, you're getting a jury trial. You want a jury trial, you'll get a jury trial in federal court. Don't forget, the amount of controversy has to be $20. It's about time they changed that. Okay. So that's the actual fact pattern. So let's take a look here. May the buyer join claims? So can the buyer join the breach of contract for the painting? Or let's see who. I'm sorry, the buyer. So we have fraud for the first one, buyer versus seller, and then buyer also sued seller for breach of contract. And can the buyer join claims? Absolutely. You can always join all the claims you have against the same defendant, and that's Rule 18. So the answer is going to be yes. It's an easy yes. And sometimes on an essay, there is no correct answer. This time there is, 100%. You can't argue any other way. The law is settled. Now, number two, are the buyer's allegations sufficient? Again, it's a no. There's no argument there. So you don't have to make any counter arguments. There's nothing to make. They did not plead with enough facts to prove fraud. Number three, does the federal court have subject matter jurisdiction in the suit? And this is where people, believe it or not, slipped up. Raise a hand. Who here actually came up with supplemental jurisdiction or would have discussed it? Raise your hand. Okay. If you did, you're actually wrong. I'll tell you, and that's what they were looking for. So if you did discuss supplemental, and if you put it there and said, hey, it doesn't apply because we have an independent basis for both, that's fine. But if you were going to discuss supplemental, it doesn't apply. I'll tell you why. We have two different causes of action. The first one we have is, again, buyer versus seller. Here, I'll put this one right here. The first one we have is buyer versus seller for $1 million. One breach of contract, they're both breach of contract. So they're both state law claims. So there's no federal question right off the bat. We can eliminate that. So for the first cause of action, for the $1 million fraud is the painting. Are the parties diverse? Yes. The amount of controversy is satisfied? Yes. So don't forget, the court needs jurisdiction over each claim against each defendant. So both claims have to satisfy subject matter. This one does by diversity. Got it. Because we have complete diversity between the parties, amount of controversy satisfied. We only use supplemental when that claim cannot independently get into federal court. So but you don't need to use supplemental here because here we have the same parties, so the complete diversity is still going to exist. And the amount of controversy is once again $5 million. It exceeds the $75,000 liquid threshold. So there's diversity and diversity. How about that? They were not. There's no supplemental. You do not discuss supplemental because you have an independent basis for both. There's no you to do. And also, and be hard pressed to find out that these two are related. That's another thing too. Now, if you brought up supplemental, you said they're not related, the court has independent basis, fine. But if you try to fit that in there, then no. They were looking for that. Because I remember when I was grading these essays, I was going through it, and I noticed that people that got supplemental got a much lower score than people that didn't, or explained that supplemental wasn't there. And of course, the selected answers do a beautiful job on that as well. Okay. Let's see here. All right, next one. We got down to number 4. Now, in terms of may the federal court apply California law to decide the breach of contract claim involving the real property? Well, under Erie in diversity cases, you apply California substantive law. However, we also have like the situs of the property. The property is in California, so you're going to apply California law no matter what. It's not a federal question issue. And I don't think they were looking at Erie, and I don't know if they were looking for Erie or if they were looking for in rem or both, because in rem deals with where the property's at. That's the law that determines the outcome. So the property's in Nebraska, you're going to use Nebraska law, no matter where you're at in federal court. All right, so California law is easily going to apply. And number 5, on what issues, if any, would the buyer be entitled to a jury trial? Well, clearly, for the $1 million in damages, you're going to get the jury trial because that's a legal claim. But on the specific performance, that's going to be tried to the judge. That's an equitable claim, and you do not get the right to a jury trial on that. And that's it. That is the entire essay for 17 July question 4. All right, so Ethan, that's a cut right there. And give me 1 second.
Perfect. Thank you, Jason.
Okay. Sorry, guys. Okay, thank you. Okay. Questions about that? Go ahead, what do you got?
So for question number 4, if the property was not in California,
Then you would use whatever law the property is, where the property is. And I'd be kind of curious to know if I guess, okay, because venue might not be proper then. Well, no, venue would still be proper because let's say they bought the property out of state. It was a Nevada property. Well, venue is because the defendant resides there. Got it? I think buyer suit seller. And well, Erie, so you wouldn't use Erie because you wouldn't apply the law of California in that regard. So I think you apply in rem or it's called situs or in rem. I forget which one it is. I'd have to look at the answer one more time. Go ahead. I think it is in rem with the yeah, which is the same thing as like saying situs, I think, because California law uses situs of the property, which determines like what jurisdiction applies the law. Got it. Thanks. Okay. Thanks, Ethan. So what was I going to say? Yeah, someone looks up the answer. Let me know exactly. I remember reading it a bunch of times, and for some reason, something's not clicking or doesn't click with me. Supplemental jurisdiction. Whoever discussed that, tell me why. What happened? Who's the one who discussed supplemental? Anyone there? Whoever had their hand up.
It was me, but I think it would have been just discuss it and dismiss kind of situation.
Okay. All right. Okay. But you would understand that it did not apply.
Right.
Who here found the supplemental did apply? Okay. And why is that?
Because I was thinking since the fact pattern started off with them making 2 contracts, like I assumed that it was done in like the same day. So that's why I'm like the same transaction or occurrence that related is.
I don't even know if they're so much related though, because they're completely 2 different transactions.
Yeah, that's where I see it.
Like think about this. If after the course is over, I end up buying your car, completely unrelated. Yeah. So thanks, Ashley. So they did mention Erie and situs. Yeah, they do mention that. But I can't imagine how Erie would apply. Did they somehow dismiss? Somehow I recall them saying that Erie didn't apply. Because think about this, like someone said, let's assume the property's in a different state. Well, you file it in California in his venue. First of all, you have personal jurisdiction because the defendant lives in California. You have venue because again, the defendant resides there. But you wouldn't apply California law to a property that was in Nevada. So that wouldn't make sense to use Erie. And I think the selected answers did kind of discuss that, if I'm not mistaken. All right. Yeah, I'll have to look at that a little bit more in detail. But Sargis, what do you got, bud?
So Jason, just to clarify, if you didn't mention supplemental jurisdiction, you were wrong to do so?
No, you're good that you didn't mention it. But if you did mention it, make sure you mention why it didn't apply, rather than try to fit it in and say that it does apply, because you would not do supplemental.
Okay, because my train of thought was like that $5 million property, I mean, it was going in regardless because of the amount of controversy. Is that wrong to think that way?
No, both, okay, there's two different claims. Each claim
Right.
has to satisfy subject matter jurisdiction. The first claim does under diversity. The second claim also does under diversity,
Independently.
independently. Yes.
Right.
So, and I think it'd be far pressed to find them related. I mean, they're two separate things. What does a fake painting have to do with this other than the same parties? So the claims don't have anything to do with each other. So again, I think it'd be hard pressed to find them related. Kind of like the example that I gave with you. Okay, got it, Sargis? All right, David Tom, how you doing, bud? Good to have you, man. And I know you probably aren't familiar with this fact pattern right now. I don't think you had a chance to read it, but go ahead. What's your question, bud?
Oh, I didn't have a question. I was just saying thank you. It's good to be here. I
All right,
appreciate it.
awesome. Harry, you got some, bud? There you go. Harry. All right, I see Harry's something up there. Okay, who else has had their hand up? What? Olivia.
Yeah, two questions. For Erie, would it be wrong? I did because we were in diversity federal court. I just said that we were going to use California because it is like property and that then I just like kind of did that.
You definitely use California law for the breach of contract claim on the fraud claim for the painting. In terms of using California law for the actual, which they're only asking about the
Yeah. Like I just said because it's property, you use California law and that it's not procedural.
Yeah, you would. Yeah. So I don't think that's Erie because again, using the example of if the property was in Nevada, because I could sell to somebody from New York a property that I own in Nevada,
Yeah.
and they could sue me in California, but we wouldn't apply California law if we're in federal court for that property because that property is in Nevada. So that's why I think it's Citus and not Erie.
I would have used Erie for Nevada as well. I just like my argument was like state law
Erie-
goes to
Yeah, but Erie applies the law of the state where the court sits. So you'd be applying California law to a Nevada property, which doesn't make any sense.
Oh, okay.
There you go. Everyone see that? So that's why I think the court applies like the rule of situs or what's called in rem jurisdiction where the property sits, because that ultimately controls it. I mean, a California court would have no jurisdiction over property in Nevada. It's up to Nevada to determine that. So yeah, again, you wouldn't use California law on that. Interesting. I think they were looking for in rem or what they call situs for California. Again, double check me on that. So there you go. This essay was super fun. I don't know why I liked it so much, but yeah. Because this is an easy question. And that's what I was saying about Rule 18. Rule 18 says you can join all the claims you want. It doesn't mean the court's going to hear them. So, like, let's say that here's a good example. He's gonna buy his car for $100,000, right? And we have a breach with that. He's also one of the one-timer students, so he's got a breach of contract claim with one-timers, or maybe he doesn't pay for like $5,000. Okay. Well, the claims are completely unrelated, right? I can still join both claims against him, but the federal court's not going to hear them. Federal court has no jurisdiction over the breach of contract claim because it's not related, there's no supplemental, and the amount of controversy is not satisfied. So that one's getting kicked down to state court. See how that works? I can still join them, which is weird because the court's not going to hear them. So I'll join both of them. So I sue him for the $100,000 breach of contract for the car. And we're completely diverse. We get into federal court, and I can, according to Rule 18 under the federal rules, I can join my breach of contract claim with him. But we still need subject matter jurisdiction for those. So the first one we have diversity. The second one we don't have anything. It's not supplemental, and it doesn't independently satisfy. So the court's got to remand that. That's why I don't like Rule 18. You see what I mean? Like, does everyone understand? Is everyone following me? I can join them. The court's not going to hear them. It's only going to hear one. The other one's going to get kicked down to state. It's actually getting kicked to small claims, but still. But anyways, that's a whole nother story. Assume it's for 30,000. Go ahead, David.
Just back on the scenario, just on.
So back on the scenario for
If this property ended up being in Nevada.
Yeah, if the property was in Nevada.
So would it still be in federal court in California? And
Yeah, you could do it in court in California because first of all, there's personal jurisdiction over S because he lives there. Then he's proper because again he lives there. All right, because venue's proper where the whole thing occurred. Which you could probably, let's say even the contract was in California. So venue would be proper in California and also Nevada, because that's where the property is located. So venue would be proper in either one. Court might even but the court's not going to apply California law to that property.
They could just reach and get Nevada law and.
Yeah, they would. Well, yeah, I wonder how they would do that. Yeah, they'd have to apply Nevada law. There you go. They'd have to apply Nevada law to that, which is interesting. Which is why I'm usually struggling with number 4. I don't know, because something about it just didn't sit right. It's interesting. Aleko and I think it's one of the. I didn't bring that question in today. He called me on a question yesterday that I totally missed, and I'm like, I didn't even know what the answer was, and it's in my materials. I'm like, how did this question get by me? I'm like, how? And then so what did I do? Like, I cut him short, and like for the next 2 hours I wrote the explanation for it, and I will never forget it now. I'll explain it. It has to do with Rule 60. We'll get into that when we go through some MBEs. Yeah, crazy. Like, this is what I mean by I learn something every day. The Rule 60's got 6 components, and for some reason, number 5 just never even registered in my mind because I'd never seen it before. Okay. Anything else about that? Okay, what do you got?
Do we just not state the plaintiff needing independent basis?
Well, so that's the thing. She's asking for number 1. Do we say about the independent basis? No, they're asking. When I noticed this, I'm like, oh, they're asking 2 separate things, and people are going to get tripped up.
I stated it, and then.
Well, you don't have to because they're asking about it here. And that's why I prefaced, she's like, she would have stated it here. I wouldn't have. I'll tell you why. Neither of the selected answers. Because of the fact that I know they asked about it here. And I wish they would have given you one where the court didn't have jurisdiction. That would have really messed people up. Because the yes here would have almost implied a yes here, and people wouldn't have understood the difference between them. So let's say this was only for $50,000. How about that? So if this was for $50,000, the answer would be yes here, but then it'd be no here, rather than yes, yes. See how that worked? Because they're not related. If that was the case, then you'd bring up supplemental and explain how they're actually completely separate. And then you would say the court doesn't have independent basis. So although you may join them, the court's not going to hear it, and it's going to get remanded to state court. Does that make sense? All right. Are you sure you're processing all that? Yeah. Got the good. So that's why I wouldn't do it here. You can always join all the, which is crazy, which is why I don't like Rule 18. You can always join all the claims you want. Doesn't mean the court's going to hear them, because now you have the subject matter jurisdiction hurdle to deal with. Kelly.
So if it was 50, you would and you would argue that there's no supplemental because it's not related, and also because it doesn't meet the amount in controversy.
Yeah. So what I would say is this one obviously satisfies diversity. Now this one doesn't independently satisfy diversity or federal question. However, it may satisfy supplemental, but it comes like whether or not they're related, and they're not part of the same transaction or occurrence. They're completely two separate things. Now I can see people making the argument that they're related, but they're really not. Because like, are they related? And it seems like they are, but they're completely not. The one thing has nothing to do with the other. If I sold you a fake painting, does it have anything to do with the house you bought? I mean, really, they have nothing to do with each other. Although, like, I could see how you wouldn't see it. And now that I think about it, why didn't they make that? But they should have done that because they wanted to see you talk about supplemental. I get it.
If it comes with the house.
Yeah, that's a couple of the house. Brittany, go ahead. And by the way, check this out. Let's say that, and this is good for contracts, so you'll understand what divisible means. Let's say that they had it in one contract, one encompassing contract. The painting for 1 million and the house for whatever, 5 million. Okay. And the guy delivered, like, let's say he delivered the painting, which is fine. That would be what's called a divisible contract. Even though, so what they are, 2 separate contracts merged into one, but they're completely distinct and independent contracts. In reality, we just merge them into one. But that's what divisible means. Does everyone understand that? So this would be an example of a divisible contract if they were all part of the same contract. All you're doing is you're taking 2 separate contracts and merging them into one. That's all you're doing with divisible. We'll get in that more in contract law, but I thought that's a good example. Brittany, go ahead.
Okay, just really quick. I just want to make sure I'm understanding. So essentially the plaintiff, so for number one, as far as joinder, as a plaintiff, you can basically bring in whatever. And then
You can join all the claims you have against that. In
related,
fact,
unrelated, sufficient, or insufficient, and then the court makes that decision.
no,
Whether-
you can always join all the claims. Like Rule 18 is very broad. So in fact, go ahead and type in FRCP, Google FRCP 18. I'll do the same.
I think she meant like whether the court takes it or not.
Well, that's a whole separate issue. So with Rule 18, it says a party may join as many claims as it has against the opposing party. So you always join all the claims you have. Whether or not the court's going to hear them is now subject matter jurisdiction, because each claim against each defendant must satisfy subject matter. Think about that. Each claim against each defendant. So if I file 3 claims against one defendant, all 3 claims have to satisfy subject matter jurisdiction. Generally, one will, and the rest of them will be related, because if that's generally the case, but it doesn't have to be the case as we have here. Does that help, Britt? Okay, got it. Okay, someone else had here. Someone else. Go ahead, Andrea. For the jury trial. The 1 million in damages will go to the jury first.
And then for the specific performance, for the breach of the contract, who will be determining that?
But both of them are breach of contract. Both of them are breach of contract cases.
That will be solved by the jury, that an actual breach of contract happened for the.
So the jury determines whether or not there was fraud for the $1 million in damages.
And for the breach of
And then for the specific performance, well, they're both breach of contract, because you breached the painting thing because it was fraud, and you breached the real estate thing by not going through with the deal. I mean, I guess that would be the claim, breach of contract for the painting, right? I mean, it's breach of contract. We had a contract, a valid enforceable contract, and you sold me something like I expected to get $1 million property. I got a property worth, I got $1 million painting. I got a painting worth $200. So I got expectation damages of nine, whatever. So don't worry about the type of claim it is. Worry about the remedy. That's all you look at is the remedy. Are you looking for legal? Are you looking for damages, or is it going to be injunction or specific performance? Or I don't know what else is equitable. You have to look at the remedies outline for whatever's equitable. Repugnance is illegal.
Really?
In fact, somebody just brought that out. Hector, I know Hector watches these on delay because he's working, but he brought that up. He goes, Jason, in your outline, it says repugnance legal. And he goes, but the selected answer is called them equitable. And it is legal. So here's the thing. And we'll get the remedies. The only things that are legal have the word damages in them, except for 2 things, ejectment and replevin. So I have a chart like on the, you really don't need to know that, but it did help me out in the last bar. I don't know if anyone took the July bar, but they had a question which really kind of frustrated me. It turns out I did get it accurate, and I'll tell you why I did. So it was a contracts question. It was a very short fact pattern. It just said a corporation was sued for breach of contract. And they would like the case to be tried to the judge. They want a bench trial. What defense should they raise? That's all it said. And one of the answer choices said fraudulent misrepresentation. One said unilateral mistake. One said unconscionability. So they're asking which of these are equitable. I'm like, what? I'm like, how? What the? Like, so I'm like, well, I know fraud goes. I know I've seen fraud cases go to the jury, so I threw that out. So I was between unilateral mistake and unconscionability. I forget what the other one was, but somehow I crossed that one out. And does everyone remember this question for the July bar? Does anyone know what I'm talking about? Does that frustrate you? I'm like, there's no way. How does anybody know this? I mean, this can't be something anybody would know. How would you know this? Does anyone know the answer? I know what the answer is now.
Is it unconscionability?
It is unconscionability. And the only reason I did, I'm like thinking I thought my remedies all. I'm like, well, I know that's an equitable defense. So if it's an equitable defense, I'm sure it's going to be tried by the judge. And that's why I put 2 and 2 together. Like, how would I know that? Like, I'm like, where in the contract outline? Where's any in the contracts book? Which I guess I could find the book. But I was like, that's a question that's I don't know, like, so these are the things that I see that they do. I'm like, what are they doing here? Pretty interesting. What'd you get an AB on that one? You remember that
I got
question?
it right. And the other option I think was undue influence, Jason.
Undue influence it was. Because I remember there being a bunch of U's. That's right. Undue influence. Why was it not undue influence? Because I was thinking about somehow I was able to, it took a little bit of thinking power on that. How'd you get incontrovertibility?
I just remembered like the defense of it being cool.
Oh, you do? How?
I have no idea.
Yeah.
It was just like in my outline that I made like
Yeah.
a long time ago, and I remembered it from class for some reason. But I was like, I'm not even sure because it was such a short question. I was like, what even are they?
Yeah.
asking?
Yeah.
Like, they're not even asking. It's just open ended.
Well, they were asking what's equitable. Yeah, essentially. I remember on my bar exam was a real property question, and it was something about trade fixtures. And I knew trade fixtures. And I wrote a great answer on it. And then I went at the end of the day, I went back to my notes and all the books that I had, including some competitor books like that buddy gave me. And I'm like, there's nothing in there about, not even in my notes or anything that I had, nothing had trade fixtures. I'm like, how did I know that? I still with this, I assume it must be something, I don't know how I knew that, but I knew it so well. Like, I'm like, oh, I know everything on trade. And I'm like, but I looked at everything I had. I'm like, there's nothing here. I'm like, how would I don't know. So your things like just pop in your head, like whatever. That's like why you should have paid attention in law school. Oh, it's too late now for that, right? Okay. Any other questions for that? All right. Go ahead. For number 2?
The fact pattern says alleging only that seller committed fraud in this was the value.
Yeah.
Could we say something in our discussion? Like
So she's saying for number 2 that the fraud only alleged fraud in the value. Go ahead.
something about intent.
So for fraud, what do you need to allege? Well, let's just take a look at rule number 9. And yeah, that's all it says. And it's 9B. It is 9B. Okay, got it. In alleging fraud or mistake, a party must state with particularity the circumstances constituting the fraud. Malice, intent, knowledge, and other conditions of a person's mind may be alleged generally. I don't know what that part means. May be alleged generally. So I would assume, what I mean, like you have to say like, in order, and here's the thing, here's the good news. I've never seen a question where they actually did plead fraud properly because it would give it away. So they're going to not plead it properly. And I've seen this on the MBE where they do something very brief that you can tell, like, no, there's not enough here. Like they make it very clear there's not enough there. Because otherwise people get it right by default by putting enough there. They're like, yeah, that seems fine. Like, so with what I've seen examples of how it does get pled is it'll say, I was buyer alleged to sell a Rothko painting that was an original. I agreed to pay $1 million for it. We had a valid contract. It turns out the painting was not as he says it was, or the painting was a forgery or a fraud, and that would be enough. And so, and because or maybe you would allege like that the buyer claimed that it was real, although he knew that it wasn't. So, and by the way, let me ask you this. Let's say that the buyer legitimately thought it was a real Rothko. Really, he really did. He honestly did. But the facts are clear that he thought it was. Maybe he bought it from someone else. He bought it from a collector for $800,000, and he was hoping the value would go up, and now it did. Now he's selling it for $1 million. Would, in that case, the seller have any remedy? So the buyer honestly, truly, so we don't have intentional fraud. We don't have that. Anybody know? We're getting this in contracts, but I want to see if anyone knows what it is. What do you think?
Rescission.
It would be rescission, exactly. Absolutely. Rescission, by the way, rescission applies like almost every. Just throw in rescission. Yeah, it's rescission. Yeah, because you can rescind the contract for like this. Well, you lied about that. Well, I didn't mean to. It doesn't matter. And the classic example is you buy a car from a dealership that has 30,000 miles on it. You sell it to me for 50,000 miles. I find out the odometer got cracked and it actually has 150,000 miles on it. And you didn't do it, but the dealership did. So they got you. Well, between me and you, it's on you, buddy. So I can't sue you for fraud because you didn't intentionally, but it's negligent misrepresentation. There you go. Or not even that, it's even if it's an innocent misrepresentation, it doesn't matter. I can still get rescission from you. Now you got to go take it up with them. That's how that works. We'll get into that in contracts again. Okay, are we good with everything? If anyone has their hand up, go ahead and shout it out while I erase this.